Who decides on arbitrator appointment procedure? Again, the parties decide. Otherwise, the model law and Arbitral rules provide default procedures. The question of who appoints involves various persons. Direct appointment by the parties is common, such as interviewing prospective arbitrators and choosing one of them. The parties may also use a list procedure or system. Many arbitral institutions have lists or panels of recommended arbitrators for the parties. More on this shortly. In a tribunal of 3 or more arbitrators, the arbitrators appointed by the parties can use similar procedures for selecting their presiding arbitrator. Involving the co-arbitrators may assist with appointing an impartial and competent presiding arbitrator. It can also reduce the risk or the perception that party-appointed arbitrators may act as advocate or at least in favor of the parties who appointed them. For default appointment in situations where the parties or other responsible persons fail to appoint, Arbitral rules refer to an appointing authority, while the model law refers to the court or another specified authority. The model law's default procedure for appointing 3 arbitrators in Article 11 is for each party to appoint 1 arbitrator and the 2 party-appointed arbitrators to appoint the 3rd arbitrator. If these appointments are not made within the specified period, a party can apply for judicial or institutional appointment. Similarly, the default appointment of sole arbitrator is to be made by the court or another specified authority. Article 11 of the model law further provides for the parties to request judicial appointment if any of the responsible persons fails to appoint the arbitrator in accordance with the parties' agreed procedure and the parties' agreement does not provide other means of securing an appointment. Such appointment is not subject to appeal, but is subject to the parties' agreed qualifications for arbitrators, as well as the arbitrators' independence and impartiality. The similar provision in Arbitral rules is Article 6, paragraph 7. However, which courts can assist with arbitrator appointment? Usually, the court at the seat of arbitration. If, however, the seat has not been chosen by the parties or otherwise determined, the party requesting for the appointment will find a court with some connection to the case. Most courts will assist, especially if there is no other convenient forum, or if their failure to act would result in denial of justice. As mentioned earlier, Arbitral rules already prescribe the appointment procedures, regardless of the parties' agreement in this regard. For a sole arbitrator, the appointing authority will appoint at a party's request if the parties do not agree on the proposed arbitrator within the specified period. Article 8, paragraph 2 requires the appointing authority to use the list procedure unless the parties agree against it or the appointing authority determines that the list procedure is inappropriate. The steps are: A. Appointing authority gives identical lists of at least 3 names to the parties. B. The parties delete the names to which they object and number the remaining names in the order of their preference. C. The appointing authority appoints from the party-approved names in the list and in accordance with the party's order of preference. D is omitted from this slide and reads, if for any reason the appointment cannot be made according to this procedure, the appointing authority may exercise its discretion in appointing the sole arbitrator.